Hello, my name is Will Cartwright, and I'm an estate planning attorney. Office is in Murfreesboro, Tennessee, and we serve this Murfreesboro and the surrounding area doing estate plans, and we also do probate as our primary function of the law firm, of the law practice. So this video today is really talking at a high level of what is an estate plan. And estate plan is going to consist primarily of a will or a trust. It's going to consist of a durable power of attorney, sometimes referred to as financial power of attorneys, a healthcare directive, a HIPAA form, and final burial instructions. So those are the core documents of an estate plan. And every estate plan is probably a little bit different. It could vary a little bit. There may be some extra ancillary documents that go with the plan, but fundamentally, all estate plans should have those core documents. So the question that I get probably most frequently is, what is the difference between a will and a trust? So most of us are familiar with a last will and testament. So well, let me first say this. A will and a trust, they're both contracts. So they're both pieces of paper that are issued, and they're a formation of a contract. Now, by themselves, they are no good. So, and let me talk about what I mean by that. A will, as we are probably most familiar with, a will has to be approved before it can distribute any assets or give any instructions. It has to be approved. So that just means a will has to go through probate. And probate is a formal court proceeding, a court process, which initially does a couple things. One, it has to prove the will to make sure that is the person that passed away, the decedent, that is the last will and testament of theirs, and that was still their intent. And then whoever's named as the personal administrator, sometimes referred to probably most commonly as an executor, that person has to be vetted by the court and approved that they can serve in that role. And then that initiates a process we call probate, which at the end of that process, we'll do a distribution based off what the will's instructions were. So again, a will by itself is no good. It's going to have to go through that probate process. Now, a trust. So a trust is also a contract, but much like a will, it's no good on its own. So a trust is going to have to, what we call, fund the trust. We hear that term a lot. It really just means the trust has to own the assets that it's going to transfer. So a common example would be a piece of property. Instead of the deed being listed in the individual name, it needs to be listed in the name of the trustee, which will then be followed by the name of the trust. If the deed is titled correctly with that verbiage in the trust, that means the trust owns it. And when that person passes away, the trust will then have the authority through the trustee at that point to distribute the property to the heirs that the trust states. Now, the big difference is the will has to go through probate, where a trust estate, if done properly, does not have to go through probate. A lot of people have different opinions on probates, rightfully so. In some cases, probate can be very time-consuming, a long process, could be expensive with legal fees, and even the executors in most cases are entitled to a fee. So wills through probate can be cost more than maybe a trust. However, not all probates are long and expensive, and probably just the opposite. Most of them are not. Now, there is some time periods that have to pass in a probate, but in most cases, probates are fairly straightforward and not all that expensive. A trust is going to be more expensive on the front end, but if done correctly, it's going to avoid all the probate process. So if titled correctly, set up correctly, then the trust estate will not need probate. It's going to pass through the heirs based on what the trust says, and that a trust will cost a little bit more on the front end to set up, but it will save. It is going to save more, and probably be done quicker with less red tape than maybe a probate would be. So those are the biggest differences. Now, depending on which one is right really depends on the goals of the estate. So when I meet with clients, that's really the first question that we'll ask is, we'll get a little family background information, and then it usually leads right into, well, what are your goals for your estate plan? And obviously, most people want to keep it as simple as possible, but depending on the goals, it may not be so simple. If it's probate avoidance, in certain states, we can set up estates through, beneficiaries or pay on death designations and have a will as a backup. But in some cases, we could possibly avoid a probate even without a trust if done correctly in an estate plan. But if it comes down to, I've got beneficiaries that maybe they have, maybe they're receiving government benefits, or maybe they're disabled in some way, or there's some sort of worries that if they receive a full inheritance, it will do more bad than it would be good. So therefore, I don't want to distribute everything outright upon my death. I want to withhold it, maybe have it discretionary, paid out over time, or maybe it's based on certain contingencies or certain ages. I mean, it's unlimitless. Well, a will cannot do that, because a simple will is going to distribute at the end of that probate process, and that probate is going to be closed, and so will the estate. So the only way to do all of what we just spoke about with giving over time or with discretion or certain contingencies, the only way to do that is through a trust. So let's talk about trust. There's ultimately two types. Well, there's two umbrellas of trust. There's many different types of trust, but they're going to fall under the umbrella of revocable or irrevocable. It's going to be under one of those two. And a revocable trust are probably the most common trust. These are primarily designed to just avoid probate, to make the transfer from to the beneficiaries as easy as possible without court involvement. And but revocable, by its word, by definition, the people who's making the trust can revoke the trust. So revocable trust means that the makers of the trust, we call them grantors, they have full control over the estate. So if they make this revocable trust, they put their assets, for example, their house, the bank accounts, they put it in the trust, they still got full control. They can still sell their house, they can still take money out of their bank accounts, they can revoke the trust, they can change the trust, they can do really anything they want. Now, upon their death, it returns to irrevocable trust, meaning their beneficiaries can't change the terms. But the grantors can still have full authority to change the trust during their lifetimes. Now, but the big disadvantage of the revocable trust is there's no asset protection. And a lot of people misunderstand that. We see a lot of coming into even to my office, and they have these trusts. They want to amend it, and it's a revocable trust, and they're under the misguidance that their assets are protected in the event they have some lawsuit against them. Well, clearly that's not the case. Revocable trust does not provide any asset protection during the grantor's lifetime. So let's talk about the other types of trust, and that's irrevocable. Irrevocable trust do provide asset protection if set up correctly, but by definition, they're irrevocable. Now, there's some exceptions to that, but that's really not purposes of this video. But I guess from high level theoretical point of view, irrevocable would mean you're going to set up a trust, but you're not going to be able to amend these trust terms. In other words, you put an irrevocable trust, or you set up an irrevocable trust, you put a house into it. It's really difficult to get that house back into your individual names. Really, you can't. It's going to be remaining into that control of the trust. Why do people set up irrevocable trusts? Well, primarily for two reasons. One, probably the most common, would be asset protection. They want to put assets into this irrevocable trust, and in the event down the road, they want to be able to, if they get sued, that no one can touch the assets that are in the trust. That's probably the most common. Now, clearly, if you think there's a lawsuit coming or got concerned of one coming, you can't set up an irrevocable trust. That would be sort of a fraudulent transfer of some point to try to avoid that wouldn't work. But if you're just pre-planning, it's a good tool for asset protection. As a matter of fact, Tennessee does have a rather unique asset protection trust where the people who's making it can also be the beneficiaries, which is unique because in most irrevocable trusts in most states, the people who make the irrevocable trust cannot be a beneficiary of that trust. Well, in Tennessee, you can. You can be a beneficiary, you just can't be the trustee. And the trustee is the decision maker of the trust. So that's reason number one, asset protection. Reason number two, maybe it's I'm going to transfer my assets to this irrevocable trust. It means I take it out of my taxable estate. So when I die, I won't be assessed inheritance taxes. There's different words. Some refer to as estate taxes or death taxes. But now, making this video early 2022, the inheritance taxes, there is none for the state of Tennessee, so you can actually pass on as much assets to beneficiaries as you so please. There is no state inheritance taxes to those beneficiaries or against the estate. However, there is a federal sort of threshold, and today it's a little over $12 million. I think it's 12.06 million. So the estate would have to have more than 12.6 million worth before any estate taxes would kick in. Now that is subject to change soon. I think if Congress doesn't touch it, it's going to sunset at some point in 2026. It's supposed to be cut in half. However, there are some talks out there that the current administration may bring it down much lower. But that's, again, beyond this video. If there is concern about estate taxes, if you throw whatever parts in that trust estate, it's its own entity. So it's removing it. So theoretically, that could pass so much under the guidelines. The normal estate, that's not the trust estate, could pass under the current threshold, and there would be no estate or inheritance taxes. But if you combine them together, then it would be. So that's, some people will set up these irrevocable trusts for those reasons. There's other reasons. People with second marriages and kids from prior marriages, and they want to provide some asset protection. There's other mechanisms through irrevocable trust to provide that sort of protection to the potential family members of the first marriage or the kids. All right, so that's kind of a broad level view between wills and trust. Again, there's a lot more detail to get in, but really the conversation will depend on the goals of the individual. What are they trying to accomplish? Who are they trying to get their assets to? And what are the concerns? And again, that's going to lead the way to whether it's a will or a trust, which type of trust. And you can even put what's called testamentary trust, which are trusts built inside wills. Those are trusts that are not active today. You don't have to fund them during your lifetime, but The will is going to go through probate, and then those trusts that's in the will will be basically become effective at that point and overseen, and basically goes from a dormant status to effective upon death. Okay, so those are wills and trusts, kind of high-level view. So the other documents, durable financial power of attorneys. So that would be the other part of an estate plan. And really what these are, it's in the event of incapacity, who's going to make these financial decisions? Who's going to pay the bills? You know, if there has to be some sort of transfer, like a sale of an asset, who's going to do this if the person is no longer has a mental capacity to execute or do these tasks? And that's really where the durable or financial power of attorney comes in. It's in that event. So there's different ways to set these up. They could be effective immediately upon signing, or they could be effective only upon incapacity. These documents are very important. Without these documents, if someone ends up in a situation of incapacity, the only other alternative would be a conservatorship, which is a court proceeding. It's going to require an attorney, and it's a little time consuming. So to really get a conservatorship over someone. Next document would be the healthcare power of attorney. A lot of people refer to these in Tennessee as advanced healthcare directives, which is what we use. And really what this document is, it takes, first part of it is really similar to the financial power of attorney. If I can't make healthcare decisions for myself, who's the person that's going to do this for me? And that's the purpose of the first part of the healthcare directive. It gives legal authority to someone to be your healthcare agent for you in the event you can't do it for yourself. And the other part of that is also a lot of times referred to as a living will, which just means you get to decide sort of these end-of-life decisions. You can pre-decide those now. So in the event you're in certain conditions, sort of end-of-life conditions, would you want CPR or a feeding tube? There's different kind of options there that you get to choose and kind of take that burden off of your family members for these end-of-life decisions. Now, we also provide in our estate plans, whoever's on these healthcare documents, making healthcare decisions, we provide HIPAA forms. So HIPAA forms just gives them authorization to any of the health records or medical records to help them make these decisions. And finally, there's a final disposition documents, really gives burial instructions or whether you want to be cremated. And if there's any kind of special instructions for the family that you feel is important. So again, that's sort of a summary of what an estate plan is. And thanks for this video. There will be a follow-up video to really talk about when you come in for the estate consult. What's going to be discussed, what's going to be asked, and that'll be in the next video. And thanks for watching.